Good morning. This is your host, Vaughn Sigmund, and you're listening to the Business Mechanic Show here on BBM Global Network and TuneIn Radio. We're also streaming live on YouTube right now, and that'll be recorded for later. You can pick it up on the YouTube channel, The Business Mechanic, and we'll also be on iHeart and iTunes and all that later this week. But I'm really excited about today's show because I have got a fantastic guest on. Spencer Hamer is on with us this morning, who is a labor and employment partner at Michelman and Robinson here in Southern California. Spencer's a pretty bright guy, graduate of the University of Southern California, and he represents employers in both state and federal courts. So he can do it all for you. He goes before administrative bodies on all labor and employment matters, including things like discrimination, harassment, breach of contract, medical leave, disability, all those things that come up on the employment side. I hear people say this all the time, man, if I could run a business without customers and employees, that'd be the perfect business. And unfortunately, I don't think that business really exists. But Spencer he's one that believes that his clients are best served by lawyers who work with them to avoid litigation. And so he devotes a substantial amount of his practice to advisory work. And I know this for a fact because I've referred Spencer to some of my own clients, and he does a fantastic job. He's something else that Spencer and I have talked about. We haven't put it together, but he also conducts training on general employment law risk with groups of his clients, and he routinely counsels on a variety of matters, including things like very common things like leaves of absence, employment agreements, workplace accommodations, policies of procedure. So he represents all kinds of industries, from healthcare to the auto industry. He has conducted numerous wage and hour audits for the restaurant industry. So Spencer is very well rounded. I know him. He's very bright. I would recommend Spencer to anybody here in Southern California that's looking for a fantastic employment and labor lawyer. So with all that, Spencer, if your head's not too big, let's get started. Welcome, Spencer. Say hello.
Okay. Thanks, Vaughn. That was quite the introduction. Hope I can live up to it here.
You will. You will. So, Spencer, I am really going to dive right into the first question today that I think anybody that's listening to this show is most interested in. And what are some of the most common mistakes that employers make when letting go employees? What I know that creates messes for you. What are some of the most common mistakes they can avoid?
Yeah, it's a great question, and there's different ways to look at that. Of course, you have at this point in time, you have numerous state and federal anti-discrimination laws, which always have to be considered. And then adding to that, you have just the general legal risks that have been there in terms of potential breach of contract and other claims that can be made, workers' compensation, things of that nature. So there's a whole variety of statutes that are out there, but I guess the good news is that the same principles sort of apply in managing the risk, regardless of what the potential statute is that could be used by an employee for a claim. So when you're terminating an employee, the things we see a lot, it's really timing is a big issue. Timing in terms of there's sort of two ways you can err on the side of being a little too early or too late, and it's hard to find that exact sweet spot. And so, sometimes we'll get a lawsuit in and we'll get the personnel file and we'll start flipping through it. And you'll see a write-up, and you'll see another write-up, and you'll say, wow, this person's been trained. This company really understands. They need to write these employees up. This is great. And then you see another write-up, and another write-up, and another write-up. And it's months of this, And so there's that side of it where there are people you're being overly cautious because there's this concern about the legal risk, and people, understandably so, but there's a time where it goes beyond that. And then, so the employee could say, well, you eventually terminated me. I understand that, but why did you terminate me for this little thing? I mean, you kept me here for 2 years, and you terminated me because I came in 5 minutes late. And well, the employer says, yeah, but we've been writing you up for 2 years. And the employee says, yeah, but that wasn't really the real reason, because the week before you terminated me for that, I told you that I might need to take some medical leave. And so it looks a little, and so that's where the timing can get you for being too cautious in terms of the write-ups. And then the flip side of it, which is probably a lot more common, is just the lack of documentation on the front side. Just having nothing in the file, whether it's for a new employee or an experienced employee. We just see that all the time. So I'd say that's much more common. And I know people probably hear documentation all the time from employment lawyers like me and HR professionals. And the reason is there's just nothing that matches it in terms of the effect, the legal effect. It really is just sort of employment law 101. And I'll add on to that I think with documentation, there seems to be a shift, which I think is a good shift. I mean, in the past, people were very reliant on the formal document in the personnel file. So, for example, a document that across the top says written performance review or written disciplinary warning, and then it would have the name and the department and the supervisor and the date, and then it would have beneath that describe incident and describe prior incidents, and then below that you'd need the supervisor to sign off and the supervisor's supervisor and the employee and HR, and that's kind of there's nothing per se wrong with that. It's just that it requires so much effort for the typical company to sit down and do that. Things move so fast, and very often companies just don't have the time, and so that's why you get the lack of documentation a lot of times, is that sort of being too wedded to that formality. And so there's a lot of pros and cons in the internet age, but I think one of the pros is it does give employers some more flexibility to document things up in real time. I mean, there's nothing wrong with email, and I've actually heard employment lawyers speak and say, don't use email as a performance tool. And I don't understand that. I mean, there's nothing wrong with sending, and you don't have to have it within the four corners of a particular looking document. We've used email to great effect in litigation and in convincing the opposing counsel that there's been extensive communication about an employee's performance issues. So that's a good thing. And text messages are sort of a second best because they evaporate and they're not always saved, but even a text message can be used. So I just encourage employers to think about that. But to go back to the original question, I think timing is definitely one of the big ones, and then the documentation, either overly documented or not documented enough.
Well, that was a great response, but I'm going to come back after break, Spencer, and I'm going to dig a little deeper into some of this documentation, because I see mistakes in this documentation as you do all the time. And let's talk about some of those mistakes. But we're going to go to break, and when we come back, you don't want to miss this. Spencer's going to share with you the things that need to go into documentation to keep you out of trouble. We'll be right back. Vaughn Sigmund, and you're listening to the Business Mechanics Show here on BBM Global Network and TuneIn Radio. We're also live on YouTube at Vaughn Sigmund, the Business Mechanic. Today we're talking to Spencer Hamer, who is a labor and employment partner at Michelman and Robinson here in Southern California. We just finished, Spencer, talking about hanging on to people too long and the mistakes made through termination. And you went down a path that I am really fascinated by, and that is the write-up or the progressive discipline performance management approach to it. We were talking about using either text messages or emails, which is fine. And you're actually the first attorney in your field that I've heard say that, which, man, does that open up a bunch of doors for people out there who hold back because of the red tape and bureaucracy of writing problems up with employees. So let's get into a little more detail and some how-tos on documentation. So you mentioned in the first part of your response is, we write them up 15 times and we fire them for being 5 minutes late from a break. How about how thematic or how much does a performance management approach have to have things in common?
You mean consistency across the different documentation or the write-ups? I don't know. I mean, I think the typical employee that isn't working out, there are patterns. I mean, you'll see, for example, the no call, no show, but you'll see it sort of manifest in different ways. So the incidents that give rise to eventually separating someone out can sort of be across the board. But in terms of the documentation, one thing that I always am kind of stressing with clients is they really focus on the tone, because you can do a lot with the tone of your communication to help yourself and to hurt yourself. And there's no reason to just gratuitously hurt yourself because you write an email that makes you seem like you're completely unreasonable. And what people tend to forget, which is completely understandable if they've never been through litigation, is that if you get into a lawsuit, then somebody's going to pull out all these old emails and all these old write-ups, and they're going to be scrutinizing every word. And email, one of the downsides of it, as everyone knows, is you can't really read tone that well, but sometimes you can read an email and you can just say, that just didn't seem that great, and I don't think that person is approaching this well. And a lot of managers struggle with that. I know they're busy and they can be demanding for good reasons. But one thing I think they should add to their just overall skill set as a manager is, I can get to the same place with these employees and I can coach them to the same result, but I don't have to do it in a way that makes me look like I'm a jerk. And it doesn't take a whole lot of changing the approach. So I would really stress that in terms of, before you hit send, just think about the tone of it, and does it make you look like you're doing right by the employee and the company's values.
Yeah, okay, interesting. And would you ever recommend that in order to monitor that tone or temper that tone, that an employer or a supervisor hold off 24 hours before capturing their whatever violation that's occurred? Just give it a little time for them to think about it and bring their emotions down a little bit.
Yeah, I mean, sometimes that's definitely a good thing, particularly if you've just gotten out of a heated discussion or something with an employee and you're about to go fire off an email. Taking the time definitely would help, or having a coworker give it a look, or running it by your HR team. I've seen that. I think that's a really good suggestion. And, there's also, you can actually put a delay on your email. On most Outlook, there's a little feature where you can hold it 5 minutes or so, and you might just pull it back and say, wait a minute, I'm going to change this just a little bit. That's another tool that managers can use.
Man, I wish I had known about that a few thousand times in my life. I'm going to have to go find that tool. But along the same lines as documentation, let's talk about progressive discipline and how many times somebody really needs to be documented before the decision is made to part ways with them. So, what's the best case or the frequency that you feel like is the best approach, the best behavior, vital behavior of, should it be 1, 2, 3, you're out, or you're warned more, I'm going to warn you again, hey, I really mean it this time? What's the best approach?
Yeah, so we talk about progressive discipline as really the thing that you do as a manager, but you don't announce it per se. I mean, when I do an employee handbook, I take out the progressive discipline language. There's no guarantee that you're going to be given 3 steps or anything like that. Now, I'll generally say I will put in language that the company will take appropriate action, and this may include verbal warnings, a combination of those, that kind of thing. So it's really you do it in practice, but you don't have to announce it. Now, in terms of what the sweet spot is on progressive discipline, it's really thinking about sort of, I like to try and envision the average person sitting on a jury, and when they're sitting there, would they think that that was reasonable and fair? And, here in Southern California, a lot of people, certainly like in Los Angeles and the bigger cities, who sit on juries are people who've been in public service and things like that, who have a lot higher standard for termination. So there's that too, that you have to think about. Not everyone is at a company where they can just be let go at will. So I think you just need to be thinking about what would the average person think, and have they been given enough time to reasonably correct the issue. So it's sort of thinking about how it would be viewed from an objective standpoint.
All right. Very good. Very good. And then another whole part of this is performance reviews, which I have some very strong opinions on, but I'm really interested in hearing your opinion, Spencer. And we're going to have to go to break here in just a few minutes. But when we come back, I want you to share with me some of the advantages and, more importantly, the perils of performance reviews, particularly annual performance reviews. So you don't want to miss Spencer's responses to this. I assure you of that. Don't go anywhere. We'll be right back. This is your host, Vaughn Sigmund, and you're listening to the Business Mechanics Show here on BBM Global Network and TuneIn Radio. Today we're talking to Spencer Hamer with the fine attorney firm of Michelman and Robinson here in Southern California. We're talking about his expertise in employment and labor law. We're going to finish up now on performance reviews, which is a favorite topic of mine, Spencer. And talk to me a little bit about some of the vital behaviors or best practices that you see your clients work with on performance reviews, not only what that looks like and from a documentation standpoint, but the frequency of it.
Mm-hmm. Okay. Well, I'm pretty blunt on my opinion on performance reviews, just after having doing this for as long as I have, in terms of seeing these personnel files and then seeing them get into litigation. So I think performance reviews is a great topic because it's one of those things that everyone sort of has in their handbook. Everyone feels like they need to do it. There's a lot of pressure around it sometimes. So just looking at it from how does it play out in employment litigation, I would just have to say that it is basically the ultimate landmine for employers, because I can't even tell you how many times we get into the lawsuit and the performance reviews are just glowing performance review after one, after another, or even just one. And then the employee suddenly terminated. And so you're sitting there talking to the client, can you explain why you did this? And it's generally variations of the same type of answer, which is, well, I wanted to motivate them. I wanted to give them some confidence. I wanted them to feel good going into the new year and that kind of thing. And, there are some people who sort of understand that there should never be a perfect performance review. I think a lot of managers do get that. And so they will put in something that's not so positive. They'll try to find something. I see that a lot. But in terms of the performance review being accurate to what they want it to be when they come and say, we want to terminate this person, can we do it? Or when they come with the lawsuit and say, we're getting sued because we terminated this person. The performance review almost always is just so different from what they're trying to say was the true story of the employment. So I've sort of gotten away from telling clients that the performance reviews are really that great. I think that you should be giving people performance feedback. Oh, absolutely. And that, again, kind of getting back to the emails we were talking about earlier, I mean, one of the benefits of the email is that you can be doing that in real time, weekly, daily. I mean, people are going to know whether they're doing a good job. And typical, if there's email involved in the company, then there's going to probably be an email chain of something, whether it's customers are happy or not happy, colleagues are getting along with them or not, and that's going to generally be reflected. And then if the manager's on top of it, there should be some added on information in there about I'm liking what you're doing or I'm not liking what you're doing. And that all has sort of the same legal equivalence of the formal year-end performance reviews. So I'm not saying you should not ever do them again, but if you're going to do them, just have this in the back of your head that is it truly the performance review? And when you sit down with someone and if they're a scale of 1 to 5 and you're going to give them a 3, how are they going to react to that? Is it better to just give them a description? And I mean, I don't know, it's sort of analogous to giving, back in the old days when they did record reviews, they would just write up the album, and they would say, this is a good album or this is not a good album, and give you 50 reasons of detail in the article. Whereas now they just kind of give it 1 to 5 stars, and that's all they look at. They don't read the article. It's kind of akin to that. I mean, a real performance review is getting into the details, and the person walks out, hopefully, if you want to keep them on, feeling sort of positive about it, that, okay, I've got some issues, but they're still behind me and they want me to improve. And you can do that with conversation and documentation throughout the year, as opposed to just coming at the end and hitting them with something. And I guess adding on to that, kind of complete the answer, is you don't want the end of year performance review should not be a surprise. I mean, if it's going to be not that great, hitting them at the end of the year with a 2 out of 5 or something, that just doesn't go over well, and that often leads to sort of a decline in the employee's relationship. And if you were hoping that they were going to improve, it often doesn't.
Yeah, that's so unfair. And do you find your clients they hold back giving candid feedback? And you said a word instead of a annual review, they ought to be getting regular feedback, which I think is critical. So thanks for saying that. But do you find that some of the trouble starts from a manager or supervisor being avoidant of having tough and candid conversations with somebody's performance, and that leads to them trying to get off the hook by, air quotes, being motivated with a overrated performance review? And would that not be somehow dissipated if they were regularly sitting down having candid feedback with them?
Yeah, absolutely. I mean, I think the glowing performance review or the overly positive performance review is sort of it's a win-win for everyone in the moment. I mean, the manager gets to feel good and they can kind of avoid the difficult part. The employee gets to feel good. And so that they're okay with it. It's more, how does that affect the company if and when the employee comes with a lawsuit later? And so, yeah, I think kind of that desire to avoid those difficult conversations is part of it, which, I think that's the real-time feedback is a good way to deal with that. You don't have to be coming down on someone and making them feel like they're the worst person ever. We always talk about with performance reviews, it should be just objective, and you don't put feelings in there, nothing subjective, just documenting up, this customer called and said they weren't so happy with how you responded to them, or, we've got a delay in the supply chain because you didn't follow these procedures, and it's just objective. You don't have to insert personal commentary or anything much beyond that other than, we really need you to improve this. This is critical, and things like that. So it doesn't have to come across as personal. And that's, from a legal standpoint for us, I mean, defending a company, that's great because we can show, look, there's no emotion here. There's no discrimination here. This is all just based on the factors that were presented to the manager at the time.
Yeah, and I'd like to talk to you a little bit more about this when we come back from break. We're going to go to break in just a sec. But I think you just hit on something that I think is vital, which is having KPIs or key performance indexes or some kind of measurement that you can compare a person's performance to numerically numerically, I'm sorry, numerically, is that a new word? Numerically, to give them an idea of comparison and how they're performing against the norm. So when we come back from break, I want to talk with you a little bit, Spencer, about that. And then we're going to talk about medical marijuana laws, which is huge here in Southern California. So don't go anywhere. You are not going to want to miss this. We'll be right back.
Horses.
Okay, great.
Present, past, and future.
Good stuff, Spencer.
Why? Free, domestic, and
So,
Yeah, I've been doing this for a while. I guess it's just sort of, I've seen so much. I don't know.
yeah, yeah, you have.
Yeah.
So it's,
I've seen that performance review issue many, many times.
oh, listen, and I've had to, well, in the end, when they do these glowing performance reviews, and then they get pissed off at an employee, and it starts going down a different route, and it just takes longer to get rid of them if you're going to do it right, because now you've got to establish a whole new pattern with this individual over a period of time, correct?
Right.
And that
Yeah, and it's funny how many times when someone's calling to terminate someone and they say, I ask them that question, and, oh yeah, they just got a raise. And, I mean, it's just so inconsistent with what they're trying to do.
I know. Well, I thought the raise would motivate them to do a better job, right?
Yeah,
Yeah,
exactly.
yeah. I want to come back and talk about KPIs and having subjective versus objective information in a review. I'm sure you've got an opinion on that, and then we'll move into medical marijuana laws. Sound good? And I also want to hit on overtime a little bit, because I see people violating that law all the time.
All right, we'll be back in about 25 seconds.
Each potential client before they decide to have surgery on the health risks of obesity and the various weight loss surgeries available. After surgery, Wait No More Consulting provides a solid support system with ongoing meetings to ensure continued success.
Okay, back in 10.
Deborah Simons and Wait No More Consulting are committed to promoting
And
your health
5,
and wellness
4,
and maintaining a
3,
healthy weight for
2,
life.
and we're back.
This is your host, Vaughn Sigmund, and you're listening to the Business Mechanic Show here on BBM Global Network and TuneIn Radio. We've got a great guest on today, Spencer Hamer with Michelman and Robinson, a labor and employment partner here in Southern California. When we left off, we were talking about performance reviews, and I posed a scenario to you around KPIs or performance metrics, where in any kind of review of an employee's performance where you have something that's a little more subjective versus objective. Talk to me a little bit how that helps or can potentially hurt having good KPIs to measure against, Spencer.
Well, I think it's generally a good idea because it helps the manager. It gives them a tool. It gives them something to kind of affix to when they're coming up with their evaluation. And it also, and I haven't touched on this as much in earlier answers, but it also helps ensure consistency of treatment across the workforce that person is managing. So that's one of the big red flags, and it sort of goes back to the first question of what do you see in terms of termination mistakes, inconsistency of treatment. I remember years ago I had a case where the employer fired someone because of their internet use and being on the internet and surfing around, and it took about 10 seconds of questioning to find out that pretty much everyone in the company was doing the exact same thing. And so it's easy to find the person you don't want, the person you want to get rid of. It's easy to find things to get rid of them for. But then the second question is, okay, but do other people have this issue with their expense report? Are they doing this as well? And so, having that objective factor, whether it's KPI or whatever the company's created to guide managers is very, very helpful. The more objective, the better. Once you get into subjectiveness in any type of performance review, then you're opening yourself up because there's cases going back many years in the discrimination case law about how do you prove discrimination. There's usually not a smoking gun. There's usually not an email or something that's discriminatory or a racial comment or things of that nature. So you have to go a different route if you're looking to sue a company. And one of the routes you can go is, well, you wrote me up for something that you just felt was inappropriate, but that's just your own belief. You don't have anything in here to really pin it down to. So why are you writing me up? And so the manager's defense of that is, no, so here's the review, and here's why it's objective, and here's what it's based on. And if it's KPI or something like that, it makes the manager's life a lot easier in having to defend something they did.
Yeah. All right. Good. I love that response. And then the next thing I want to talk about. Well, let me back up just a second. Job descriptions. Does that not help in the means of measuring a person's performance when they start on day one, understanding they've got an employee manual and a job description that they're being held accountable to from a performance standpoint? How often do you see that as being a benefit or being something that's a detriment because it's not in place?
Job descriptions are a huge benefit. I don't think there's really there's no negative that I can think of really to a job description unless it's written, unless it's in the execution. The concept is great. I think everyone should be using these, and I don't know, of the clients that I deal with, I'd say maybe 50% do. So there's a huge gap between what you should be doing out there and what's getting executed. But I think that it's a variety of things. I mean, it's for performance, so you can just pull out the job description and say, yeah, it's here. You don't want to sometimes employees get overly fixated on the job description, like if it's a union environment or something like that. So you always want some wiggle room in the job description that additional tasks may be assigned from time to time or something like that, so that you don't just think, well, these are the 10 things I do. But then it has other benefits that are kind of lesser known. So, for example, with disability accommodations, it can be huge. If somebody comes and says, I need an accommodation for my disability, you want to go to the employee and say, all right, that's fine. Here's your job description. Can you take this to your doctor and let us know what they think about how you're going to perform these duties with or without reasonable accommodation? And there's a form we use for that. It's really simple. And then you've got the whole process going from the very beginning in the right direction. You haven't asked about their disability. You don't care. You don't even need to know the details of it. All you need to know is, hey, here's your job description. Can your doctor tell us what you need? We're happy to help. And that's good. Wage hour, it can be very helpful. So if you've classified someone as exempt and they come and sue you and say, no, I was non-exempt, and they have a job description that has all kinds of exempt duties, that's going to be very helpful. And then there's actually an affirmative defense in the law, in the wage hour law, that if they're deviating from their written job description that was exempt, you can say, well, this was what we expected you to do, and you weren't doing what you knew you should be doing. So the fact that you were in the back filing things all day long when we didn't even know that's not what we wanted you to do. That's a non-exempt task, but that was never assigned to you. So it really can just help you in a variety of ways to have a job description, and really everyone should do that when they hire on, and certainly for people that are calling exempt. I mean, that's critical.
Well, let's take that a little step further, because I do see that exempt versus non-exempt being violated on a regular basis. Describe for anyone who's listening today what exempt versus non-exempt, or who they should be paying overtime to, what the rule of thumb is versus who they can salary. Would you hit on that a little bit, Spencer?
Yeah, I mean, it's a pretty complex topic, but just to hit the real high level, and you got to look at your federal and state laws. So whatever the law of your particular state. Here in California, they always tweak things just a little bit to make it extra difficult for employers. So this is a caveat of you got to look at your local laws, but the main exemptions are the white collar exemptions. So the managers, the administrators, and the professionals. And I think the biggest misconception that we see is if someone's they'll say, oh, they're salaried, so they're exempt. Well, that's only part of the test. So they have to make a certain salary under federal and state law. They have to meet a threshold. And then they also have to have the duties part of it too. So they have to have the proper duties assigned. You have to get both factors, not just, oh, their salaries, so they're exempt. And I've seen that many, many, many times.
10
So
seconds.
if you've got exempt employees, the best thing to do is have a professional review them and make sure they're properly classified.
Great response. Thank you for that. We're going to go to break for a minute. When we come back, we're going to talk about medical marijuana laws here, and also all the entrepreneurs here in Southern California are getting into that industry. Don't miss this. We'll be right back.
There are artists, and then there's
Okay,
Alex
great.
Salzmar, this award-winning artist. who spent
Thanks
his
for
entire
clearing
life
that up. That
working
is
to
one,
protect
Spencer,
his
that I
and
see
his
screwed
icon
up. And,
fascination
well,
in
yeah, you just dealt with one of my clients on that. And thanks for helping him out. But it's one that I see people are really loosey-goosey with, especially in the smaller size businesses, right?
The National Museum of American History and the Smithsonian
Yeah,
Institution in
it's
Washington,
mind-boggling to me. I mean,
four
these
artists in the
overtime laws have been around since the 1930s at the federal level, and so the basic concept is out there, and to have people in 2017 not paying overtime because they didn't have a time clock in place, or because they're a new business, or because they didn't know, and it's crazy too, because now there's like 50 apps out there that you can get in no time that track time. So even so I have a construction industry client that uses this app, so people are at a different job site all the time, and they just use the remote app, and it takes a photo of them at the job site. So, the technology, especially with wage hour, is there now. That should just be dialed in, like literally. So, and I'm still talking to clients all the time saying, get an app and have them put it on their phone. Because there's a lot of drivers and, different industries where people are out and about that have historically just gotten crushed with these lawsuits. Because the people aren't writing down their time.
Yeah, well, and it does get expensive,
Sorry,
right?
we'll be back in 20 seconds.
No, it's crazy. Yeah.
Better Home and Garden is an online retailer offering a wide variety of high-quality brand name merchandise at
All right,
discount
back in
prices.
10.
Our service is personal, and we aim to please. Visit us
And
at
5,
www.betterhomeandgarden.com.
2,
Make your home
1,
your own.
and we're back.
Welcome back. This is your host, Vaughn Sigmund, and you're listening to the Business Mechanic Show here on BBM Global Network and TuneIn Radio. We're talking to Spencer Hamer today with Michaelman and Robinson. He's a fantastic labor and employment attorney here in Southern California. Overtime, Spencer. Worst case scenario, what are some of the fines and penalties? And you and I see it being pretty loosey-goosey with a lot of employers here. But when they get caught, when they finally make somebody mad and that person gets terminated or they quit, they're going to come back and they're going to hit them on unpaid overtime. What are some of the fines and penalties that employers run the risk of having to pay?
Well, for those of people who are listening in California, I mean, it's a whole different situation out here than compared to most states, because here, if you don't pay overtime or you don't comply with the wage hour laws, then all kinds of other statutory fines and penalties kick in. For example, you haven't paid if somebody's separated out and you haven't paid them their overtime, that means you also didn't pay them their final wages, and you owe them 30 days more of wages. There's a pay stub penalty for incorrect pay stub. There's all kinds of things that start kicking in. And so, and of course you have the attorney fees too. So most of these wage hour claims, or the wage hour claims in California, and even at the federal level, if you prevail, you can get attorney fees. So that's another big kicker. And if you think about that, that means, so if you haven't gone through this before, the pain of it is if you get sued and you're found liable for the overtime, you're not just paying your attorney to defend you all the way through. If you lose, you now have to pay the fees of the other attorney. And what's crazy about that is that there's no law that says it's a 1-to-1 ratio or anything like that. So you could be looking at, let's say, hypothetically, $20,000 you owe the employee, and the attorney says, yeah, but you made me try this case. You owe me $200,000. So that's a painful realization for a lot of employees who've never been through that. Now, if you take that and the fines and the penalties, and even at the federal level, there's other fines and penalties and interest and things. But if you take that, and the typical wage hour case, the attorney who's taking the case is only moderately interested in just one employee. I mean, they're doing their job. They're trying to represent their client, but they also want to know, are there other people out there that I can bring this claim on behalf of too, either by a class action, or in California we have the Private Attorney General Act. So, having one employee claim, okay, fine, they'll take that, but can I now make this a 20 employee claim, a 50 employee claim, 100 employees? And what the other kind of kicker to this is that doesn't just include your current employee population. That includes anyone you employed during the statute of limitations period. So out here, that's typically 3 years. It can be extended back to 4 under the unfair competition law. And so that can be a huge number. Even if you only have 30 or 40 employees, you could be looking at 75 to 100 employees over a statute of limitations period. So now when you add in the penalties and the interest and the attorney's fees, it can be a bet the company type scenario. And given that situation, a lot of employers are really in a bind. And to top it off, and this is something we haven't really talked about, but employment practices liability insurance, typically those policies are not covering the wage hour claims. So you may not even have insurance for this. Now, there is a way some companies will offer some cost of defense coverage for that is typically what we'll see. But that's not the same as liability coverage. And I'm kind of getting into a whole other topic here, but the point is, a lot of employers have to learn the painfully hard way that, I didn't pay one person overtime and I owe that person, that would only be maybe $5,000 or $8,000, but that's not necessarily the end of the story. So when you add it all up and extrapolate it across, yeah.
So they violate it with one, they potentially are chumming the waters for all that came before them and the existing employees. That's tough to swallow. But a great and classic warning. Thanks for putting that out there. So let's talk about the burgeoning marijuana industry here in Southern California, all of California, and really the rest of the nation. It's really growing like crazy. It's the new gold rush. Let's talk about, if you would, offer 3 or 4 really good pieces of advice for all, and it's overwhelming, the number of entrepreneurs that are wanting to get into the medical marijuana or the legal marijuana industry. What are some of the 3 or 4 things, Spencer, as their online attorney, if you will, their radio attorney, what they need to make sure they've got in place before they start their marijuana business?
Oh, okay. You mean you're asking as if
they're a new employer.
If I were opening up I'm going to be opening a medical marijuana business, and what do I need to know?
Yep.
Okay, it's an interesting question. Well, this is a cutting edge area of the law, obviously. I mean, just in the last few years, all these new states, and I can't even keep track anymore, have passed medical marijuana laws to the point where I think I read that by the end of 2016, in the majority of American workplaces, there's some form of legal medical marijuana use, and so for the first time. So the case law is going to have to catch up to all this. There's not a robust area of case law on this, but a couple things we see a lot. Employers calling and saying, hey, this guy says he has the right to use medical marijuana. What do I do? Can I not hire him? Does he get to use it at work and all of this? So in California, the California Supreme Court has a decision out there that says that it's still unlawful under federal law to use medical marijuana, so you don't have to accommodate that type of use on the job. That's not a right or anything like that to come and take medical marijuana at work. So on-the-job use is still, you don't have to accommodate
30
that.
seconds.
The sticky part is sort of where it interacts with disability laws. And I don't know if we have enough time before the break, but that's kind of a whole other topic, because addiction is a disability, but current use on the job is not protected. And so there's a point where that intersects, and it can create all kinds of problems for employers.
All right, we'll have to maybe we'll probably do a whole show on this, but maybe we'll plan that sometime in the future. But we are going to go to break, and when we come back, I want to talk to you some. I hear about this. Employers get so frustrated with their employees on social media all day, and maybe even involving their employer in some of their social media. So when we come back, Spencer, I want to get your viewpoints on social media rights, employee versus employer. Don't go anywhere, folks. We'll be right back.
Okay, great. We can just play this one commercial, and I can get you guys back on if you want to talk for a little longer.
Yeah, let's do that, because I do want to. This is one last one, Spencer. If you can hang with me another 5 minutes and talk about social media, and then we'll get you out of here, and I'll wrap it up.
Okay, sounds good.
Okay.
All
Thanks.
right.
Thanks,
And
Barry.
of course, yeah, no problem. So I'll give you guys a 2-minute warning just to know, like, getting closer to wrapping up, and then 30 seconds to wrap up the whole thing.
All right. Thanks.
Of course. We'll be back in about 20 seconds.
At JobsAnnex, we provide you with the tools to tell your story for free. Our resources at JobsAnnex.com will help each applicant construct an award-winning resume. And
Okay, back in 10.
key interview questions to ask in various types of interviews. Best of all,
And
it's free.
5,
JobsAnnex.com.
4,
That's
3, 2, 1, and we're back.
Welcome back. This is your host, Vaughn Sigmund, and you're listening to the Business Mechanic Show here on BBM Global Network and TuneIn Radio, where we got a great guest on today, Spencer Hamer with Michelman and Robinson, labor and employment attorney. When we left off, I warned you we're going to come back and talk about social media, which is a huge frustration. I see it all the time with the clients that I work with, Spencer. Talk to me a little bit about the employee versus employer rights when it comes to the use of social media at work.
Okay, yeah, it's a great question, and this is one of the reasons employment law is an interesting practice area, is because it's always changing, and I would say in the last 5 to 10 years, the social media aspect of the practice has been one of the most just robust in terms of the development of the law and what we have to pay attention to. And just so sort of a broad brush overview, I mean, people might be thinking, I don't understand, what does social media have to do with anything legal? And sort of the main reason it's become such an issue is because of all administrative bodies, the National Labor Relations Board sort of took up the social media charge, particularly during the Obama administration, and issued a whole bunch of decisions and guidance on social media, and basically the idea being that employees have a right under the National Labor Relations Act to discuss terms and conditions of employment with their coworkers, and that's a protected right. And you have to practice labor law. Most people don't realize this, but you don't have to be in a union to have that right. You can be sitting in the break room with 2 or 3 employees in a regular non-unionized workforce and just saying, "Hey, I don't know if they're paying us properly here, and I don't really like what they're doing with the 401k. I think there's something wrong with that." That's actually protected activity under the National Labor Relations Act. So it kicks in a whole host of, a body of law going back decades on the rights associated with that. So then, if you transfer that into the social media setting, what happens if an employee is sitting at home on the weekend on Facebook, they're friends with a bunch of people at work, and they throw out a post that says, "Hey, I'm not real sure that our vacation policy is right because I just got shorted about 10 days last year, or I had to use it or lose it policy," or something like that. That discussion is all protected. So then what if a manager is sitting there watching that, and one of the employees says, "I don't think this company treats us fairly," and the manager terminates that person first thing Monday morning. And that's where all these cases started to come out of. And there's a whole body of law now that's starting to get developed. Now, the flip side of that is that the employees can't just go on and do anything and say whatever they want about the company. They can't say, for example, "Hey, I'm really excited about our new product. We're launching it next month, and it's going to be this self-driving car, and here's all the technology." So you can't disclose confidential information. You can't harass people in a way that's unlawful or against company policy, things of that nature. So that's where the cases have generated all this tension of between what the employer can legitimately police and govern, and what the employees have the right to say. So employers they're coming across social media issues, and I can't even keep up with it anymore because I'm getting too old. All the ways that it comes up, I haven't even heard of these things by the time they hit my desk half the time. But the employers just need to be in touch with HR or legal about these issues because they can be tricky. You can't just jump off and act in haste and terminate someone because they made a complaint about the company online necessarily. You got to look into it.
Great response. And based on that topic alone, Spencer, I think you're going to have plenty of work to do for decades to come. I'm gonna thank you very much for educating us all this morning, Spencer. I so appreciate it, and I'm sure you and I will be seeing each other soon. Thanks so much for your time this morning. Great information.
Okay. Thanks, Juan. Thanks so much.
Good. Talk to you soon. So, listen, I don't know about you guys. That was one of the more valuable 30 or 45 minutes I've ever spent in my life.
30 seconds.
We talked about documentation. We talked about performance reviews, medical marijuana. We talked about social media. That was awesome. So we're going to wrap it up for today. Thank you all so much for listening. This has been a pure joy. We'll be back next week. Visit me at vsigmund.com. Follow me at Twitter at vcsigmund. Please subscribe to my YouTube channel, Vaughn Sigmund, the Business Mechanic. We will continue to put up our podcasts and our videos. I've got my collaborative leadership development training weekend coming up September the 9th and 10th at Old Ranch Country Club in Seal Beach, California. Please go to my website, sign up for that. It will be a great weekend for you. Thank you all for listening. We'll talk to you next week.
Okay, fantastic.
Business Mechanic with your
All right.
host,
Thank you, Perry.
You're so welcome.
All right. Good show. Thank you very much. And I'll talk to you next week, my man.
All right. Yeah, sounds great, man.
All right. Talk to you soon.
All right. Take care. Have a good one.